Thank you very much for the invitation to participate in the meeting here. And thank you for giving me the opportunity to have an exchange with you. Civil and criminal cases between Europeans and natives in the German colony of Cameroon were not the subject of any law. This only changed 1894 to 1896 when several scandals came to the attention of the Reichstag. The first of these was the so-called Leist and Whelan cases. In 1893, Heinrich Leist was serving as acting governor of Cameroon because Governor Eugen von Zimmerer was absent at the time. During that time, Dahomean soldiers revolted. They were police soldiers who had served the German colonial administration efficiently in military campaigns against oppositional chiefdoms in the colony's interior. They had been bought in their homelands in West Africa and then forced to work in the German colony of Cameroon for 5 years without pay. To keep their families alive, the soldiers' wives were forced to prostitute themselves to whites and blacks. Acting Governor Leist forced these women to be at the disposal of his guests and to work in the governor's plantations. When the Dahomean soldiers and their wives eventually refused to accept the conditions and the women stopped working, Leist's reprisal was cruel and humiliating. He ordered the women to be stripped naked, placed over barrels, and beaten in the presence of their husbands. At this point, the Dahomean soldiers decided to kill Leist, but failed. However, they did kill another German. Leist then hanged all the Dahomeans who were unable to escape and sentenced the women to hard labor on a distant plantation. The case of the colonial official Ernst Whelan involved, among other things, the burning of a number of native villages and the sexual abuse of native women. The Reichstag discussed both cases. Social Democratic leader August Bebel charged Whelan with torturing, starving, mutilating, and killing a large number of natives. Some of the parliamentary delegates asked that Leist be put on trial. The proceedings, which took place after some time in a military court in Potsdam, resulted in a verdict of guilty. Leist was removed from his office and offered a position of equal rank but lower pay. His sentence was typical of cases of European cruelty to natives and is evidence that the ill treatment and even killing of natives were considered to be minor crimes. Nevertheless, the Reichstag debates on the Leist and Whelan cases led to publicity, which in turn forced the government to act. On the 14th of February 1894, The director of the colonial department of the Foreign Office in Berlin, Dr. Paul Kaiser, wrote a letter to the colonial governor of Cameroon, referring to the debate and explaining the urgency of working out legal rules to prevent the abuse of power by colonial officials in Cameroon. According to Kaiser, one could not aim to codify everything in the same way it was done for civilized people, but it was possible to set a clear framework in which jurisdiction could function. As an example of such a framework, he pointed to the New Guinea native laws of 1888. This first letter by a member of the colonial administration in Berlin on legal matters relating to Cameroon is interesting because it makes an explicit distinction between jurisdiction for natives and jurisdiction for civilized people. The principles of law and justice, as understood in Europe, were extended to the colonies but were also transformed, losing their universality in favor of a special relativity in conceptions of justice, a relativity itself imagined and created in Europe. While the German colonial administration relativized the universality of justice, that relativism did not admit the validity of justice as practiced by natives. This was dismissed as no justice at all, as the formulation was at the time. The discussion spurred by Kaiser's letter led in 1896 to the first decree from an imperial chancellor. Dealing with jurisdiction over natives in all African protectorates. An additional decree legalized corporal punishment, flogging, as standard penalty for minor offenses, as well as for special situations that were considered crimes in the colony when committed by natives. Among them, for example, insolence toward one's master and laziness at work. The decree specified the conditions under which flogging was to be carried out, including the type of whip to be used, and it also stated that children under 16, persons of Arab and Indian origin, and probably as a result of the lice scandal, women were not to be whipped. Elsewhere in the decree, other penalties were specified for certain offenses. In this way, the entire decree aimed to make penalties more humane and to avoid future criticism in the Reichstag, especially from the ranks of the Social Democratic and Center parties. The historical records show that Berlin's colonial administration found it necessary to send many reminders to Cameroon officials, urging them to strictly observe the decree, an indication that its aims were not easy to attain. The decree had another goal as well: to give European plantation owners the means to force natives to work for them. The labor issue remained a problem in Cameroon up to the end of German colonial rule. Various strategies were developed to compel natives to give up their way of life and work for Europeans. One such measure was the introduction of a head tax, later changed to a hut tax. Another means was of a legal nature. The government refused to force natives to work, but once these natives were under a labor contract, their employer was given a legal means to force them to work. Between 1894 and 1898, and then again in 1901, the Colonial Council was established, a body of experts to advise the colonial department. And in 1890 it held an intensive discussion about creating colonial penal law. Many members of the council had colonial connections and even personal colonial business interests. The discussion in the colonial council shows clearly that different visions of colonization were in operation, and that these visions could not easily be harmonized. Those members with colonial connections advocated laws that would serve the interests of the German plantation owners. So they proposed penal laws that would give plantation owners maximum power over the natives, even including the right to force even people not under a contract to work on their plantations. They considered colonization as a matter of exploiting the colony's resources, and they saw the natives as one of several means to do so. This group therefore criticized the German administration's practices and emphasized the need to rid it of philanthropic and Christian considerations. Only then would the natives be freely available for the benefit of colonists. The typical example of this argumentation can be seen in the minutes of the Colonial Council. It gives quotations from Dr. Julius Scharlach, a lawyer with colonial business connections, who protested against the idea of extending a uniform system of justice to the people in the colonies. I quote, "What he, that is Scharlach, misses most of all as the highest principle is the recognition of the superiority of the whites. According to him, one cannot and ought not speak of any equalization of the blacks. Every violation of the personal dignity of whites must be met with the severest punishments." One cannot avoid the fact that the natives in our protectorates are our subjects, and, moreover, subjects that belong to an inferior race. It is simply insupportable to demand that the natives be treated as our equals, that they are not, and that they are incapable of reaching our cultural level even after 100 years of freedom, This is shown by, among other things, the current conditions in the Negro Republic of Haiti. End of quote. Other members of the Colonial Council advocated the creation of laws that conform to the principles of law, humanity, and justice. This second group was responsive to pressure from churches, the Reichstag, and international opinion, which had already criticized the treatment of natives in the German colonies. The members of this group favored the principles of the Enlightenment and modernization. Colonization was to be a civilizing mission, as the Berlin Conference had stressed. These principles had several philosophical implications, as we have seen. That all mankind is one and that all people have the same natural capabilities and rights. That humankind is perfectible thanks to continuous progress from a primitive situation to intellectual and cultural perfection. And eventually, that the non-simultaneous is simultaneous. That is, that people living in the same period can belong to different stages of human evolution. This second group in the Colonial Council therefore argued that penal colonial law ought to treat natives as human beings and be a means of educating them to reach a higher standard of civilization. One such council member was, for example, Dr. Herzog, who responded to Scharlach's comments as follows. I quote, "The formal objections that the previous speaker raised against the draft of Article 11 may be partly justified, but he goes too far in his demand that the average black understand the laws. Even the average German is not always capable of understanding the text of our law books." His, Herzog's, objections are, however, directed primarily against the professional position of the previous speaker. The one-sided establishment of German rule cannot be justified, at least from the standpoint of civilization. The position of lawyer Dr. Scharlach recalls that of the Spanish conquistadors. Taking into consideration the native's character, which is more naive than evil, the committee believed it ought to create milder laws and thus emphasize the educational impulse more than the deterrent one. In addition, he, the speaker, Herzog, cannot simply accept as dogma that every white is a sacrosanct and superior person. That depends on the dignity of the individual, as much in the colonies as here in Germany. End of quote. A second discussion held in the Colonial Council in Berlin in 1897 reproduced the same opposite standpoints, only the categories of the discourse had changed. In 1551, the position of Las Casas had prevailed because it accorded with the interests of the church. In 1897, the legal project that was ultimately adopted represented a compromise between the two positions. It was not an easy task to couple humanistic discourse and civilizing aims on the one hand with a colonial reality based on violence on the other. Perhaps that is why the proposed laws were never applied. Instead, the drafts were sent to the colonies for further discussion there. One of the various written reactions came from the district judge in Douala on the 15th of July 1901. His general comment drew attention to the idea that it was necessary to be familiar with natives' customs and legal concepts in order to ensure that such customs and legal concepts were not included in colonial jurisprudence. Instead, the goal ought to be to move away from these customs and concepts by way of appropriate, carefully elaborated laws that aimed at gradually changing them. The judge advocated a legal method that would be capable of transforming the existing native mentality into a new one, which was precisely why the existing mentality had to be thoroughly studied. He stressed the difference between issuing a law in Europe or in a colony. In Europe, jurisprudence was the expression of the legal concept or philosophy of the people, while in the colonies, it introduced something new, unknown, and foreign. Here it had an educational function and a political and administrative goal. It was not possible to separate these three functions in the colonies in the same way they were separated in Europe. The reactions from officials in the various German colonies showed how impressed they were with the comments from the judge in Cameroon. One consequence was that some of the proposed legal articles could immediately be put into practice in Cameroon, even though they had not been officially promulgated. A second consequence was that the governor of Cameroon gained more power over the implementation of existing laws and the formulation of new measures. The first effect of this power was an instruction issued by the governor on the 15th of October 1910 that established a difference between common law penalties and disciplinary penalties. Common law penalties had to be decided according to the German Penal Code, while disciplinary penalties, importantly, these were all related to labor contracts, had to be decided according to special colonial laws and regulations. This solution, based on the concept of evolution, did not solve the fundamental methodological problem of imposing a foreign law. The very problem described by the judge in Douala. But it did serve to reconcile the contradiction between respecting Enlightenment principles and serving the colonists' interests. A number of letters sent by the governor to colonial officials made clear that most of the officials abused this distinction intentionally by recategorizing common law and other cases that had to be decided according to the German Penal Code as disciplinary procedures. This practice gave the officials much more autonomy and power. From the very beginnings, there were contradictions within the system. It was based on universalist basic assumptions that were constantly changed. and eventually was based on a regime of reason that was forced to coexist with its opposite. The complexity of the process was becoming obvious in the fact of the brutal penalties that had disappeared in Europe, but they were still mirrored in colonial jurisprudence, but also that in the colonies there was no equality before the law. That class and race-specific justice was the call of the day. Colonization sought to export the Enlightenment, but the whole process brought a regression to phenomena of pre-modern times in Europe that from the Enlightenment standpoint were seen as regrettable. Europeans intended to combat alleged local wildness so as to establish a civilized order. But colonization, in fact, introduced a reign of violence and injustice. These contradictions were inscribed in the very nature of colonization. The attempt to give a legal foundation to an illegal act was destined to end in farce. Thank you.